Okay, I think we waited enough and we can start. Thank you all for joining us to this de facto fourth meeting, fifth meeting of the series, The Occupation and the Law, hosted by the Rosa Luxemburg Foundation in Tel Aviv. I'm extremely happy to see so many people here taking the time to listen and talk about a very contentious issue. And today we will be hearing also from my good friend and colleague, Omar Shaakir, which I will introduce in a minute or two. Before that, I would like to say that this meeting is held in Zoom, unlike the previous meetings, both because Omar cannot attend the Rosa Luxemburg offices in Tel Aviv for a reason I will also detail in a moment. And it will be great to get your feedbacks, whether people would like also to resume to the model in which we had both meetings in person, physically in the offices, and on cyber. So the topic for today is the issue that has been in some way taking first place in the discourse on Israel-Palestine, on the Israeli-Palestinian conflict in the last probably 2 years. And I'm sure you have all heard the allegation that Israel is committing the crime of apartheid, which is an international crime, classified as a crime against humanity, no less. As a matter of fact, the discussion on the relevance of the term apartheid to the Israeli-Palestinian conflict is very old. That discussion began not with any of the recent reports that you've all heard of by Israeli, Palestinian, and international human rights groups, and even UN officials. But it began decades ago when Palestinian intellectuals and Palestinian rights groups have been using the term to describe the experience that they have felt, that they are feeling when they are trying to describe the Israeli-Palestinian conflict. Now, as a personal note, I would like to say that I began working on cases that are that stem from the Israeli domination over Palestinian lands more than 2.5 decades ago. And for me, it was very clear that the occupation paradigm, the international laws of occupation, which we've been talking about in recent meetings, and trying to characterize the principles, the underlying principles of these laws, this field of law, of international law. This paradigm was supposed to explain what I see and what I witness and what mainly my clients are witnessing in the occupied Palestinian territory. And together with my friends, very good friends at Yes-dין, we've been visiting villages across the West Bank. We had cases in East Jerusalem, and I had also cases dealing with Gaza, the Gaza Strip. And as time passed by, and the more we learned about the huge matrix of policies and practices that Israel applies to these territories, it was clear that the apartheid framework is not wide enough to carry the full weight of the reality that we've been witnessing and that our clients and the Palestinian communities and the Palestinian individuals and families have been witnessing and suffering from. That maybe occupation can explain some things, but it can't explain all. that's when we at יש-דין decided that we need to look well into an alternative model, alternative framework, paradigm, which is not instead of the issue, the idea of framework of occupation, but in addition to it. So, and that's how the study that eventually I came to author on the question of the commission of the crime of apartheid by Israel in the occupied territories has came into being. In parallel, very not far away from us, my very, very good friend, who's also a colleague, and I'm honored to say a client, Omar Shakeer, has been working on a much more extensive report that looked at the same question from a wider lens. And he was doing that for the International Human Rights Organization, the renowned, famous human rights organization, Human Rights Watch. Now, I would like to pass on the floor to Omar, but first I would like to say a few words about Omar. So Omar is the flagship, the generic human rights defender. If you want to look for a prototype of how a human rights defender should look like, this is Omar. He has been working tirelessly and with a lot of courage in many corners of the world, writing reports that angered many governments, including his own, the American government, when he worked and represented detainees in Guantanamo for the Center for Constitutional Rights. He has written a very important report on the damning effects of drone strikes in Pakistan. He has angered the Egyptian government when he researched and publicized a very important report on the Rabaa massacre, where Egyptian protesters were killed by the Egyptian forces. And he was deported from Egypt de facto because of his work there. He was denied entry to Syria. He was denied entry to Bahrain. I think what more can I say to prove to you that he is really an exemplary human rights defender. And in this tone, he also was deported from another country, and that is, embarrassingly enough, the State of Israel, that decided that although he serves as the Israel-Palestine country director for Human Rights Watch, because of his work and because of his statements throughout the years since he was a student, demanding that businesses would not cooperate with human rights abuse in Palestine, including when it comes to settlement produce and things like that. That was considered by the government of Israel a BDS activism, and since 2016, they launched a campaign to deport him from Israel. I was, as I said, honored to represent him in Human Rights Watch. I was not successful, unfortunately, but we managed to have him around for at least 2.5 years, more than what the government wanted. And now he is the country director for Israel-Palestine, and he manages this position from Amman. And apart from that, he's just extremely kind and sweet person, and not all human rights defenders are like that. So Omar, the floor is yours.
Thank you, Michael, for those kind words. I would remind the audience that Michael was my lawyer, so I would take his kind words with a grain of salt, and you can make your own judgments about my, sweetness and niceness at the end. But I want to really thank the Rosa Luxemburg, Foundation for hosting, this conversation. It's really an honor to do it with Michael. Beyond being, my lawyer and colleague and friend, him and I have been discussing apartheid for many, many years now. And this is actually, I think, Michael, the first time we do an event with just the two of us sort of going back and forth together. And it probably replicates conversations that we've had bilaterally, from New York to Tel Aviv to Ramallah, and now via Zoom, unfortunately, the last couple of years. So what I hope to do in this presentation, and cognizant that this is part of a larger series that many of you have been a part of, but also some of you are tuning in because of this topic for the first time. What I want to try and do is build on, sort of what's been discussed in this series as has been described to me, by looking at another area of law, apartheid, but also applying it to the reality in Israel and Palestine. I'm going to hopefully, do that, laying out the law, our research, and I look forward to having the majority of the time for conversation, because I just know I see familiar faces in the audience, and I hope we can have a robust discussion about many aspects of this, and having also Michael with us who's thought about these issues, I hope will enrich the back and forth. Let me start by saying a little bit about Human Rights Watch. Again, I think with this audience, you're familiar with Human Rights Watch's work, but let me say a bit about our work in Israel-Palestine, because in some ways, Human Rights Watch's journey is not so different than the journey of this particular lecture series. For 30 years, Human Rights Watch documented human rights abuses across Israel and Palestine by all government authorities. Obviously with a focus on the occupied Palestinian territory. And we, probably around the 50th anniversary of the occupation 5 years ago, but even before that, we started to take a step back. We looked at our body of work, and while we felt like Human Rights Watch had documented really critical developments across Israel and Palestine, we felt that our research was failing to speak to the underlying reality on the ground, a reality in which one government primarily rules over an area where two groups of roughly equal size live. So again, I'm talking here about the Israeli government ruling over the area between the Jordan River and the Mediterranean Sea, where about half the population is Jewish Israeli, about half the population is Palestinian, and where that government's policy has methodically sought to privilege members of one group, Jewish Israelis, and systematically repress members of the other group, Palestinians, at varying degrees of intensity, but across the board and systematic. Now, that simple description of the reality in Israel-Palestine is so at odds with how the conversation is discussed globally, and frankly, even in Israel-Palestine. But we set out with a very different research topic, right? So instead of saying, let's look at, access to land in Israel, or let's look at freedom of movement in East Jerusalem, or let's look at freedom to build in one of these areas, we took a step back. We said, how does the Israeli government treat Palestinians? With that question, we went on two tracks, right? So on one track, we researched the facts, and that's where we started as a human rights organization. So we spent 2 years methodically looking at how the Israeli government treats Palestinians. So we not only did case studies across the West Bank, East Jerusalem, Israel, and Gaza, where we compared communities living side by side, one that's exclusively or primarily Jewish, one that's exclusively or primarily Palestinian, against Jewish communities. But we also looked at big picture data. We looked at years of Human Rights Watch research. We looked at research by Israeli, Palestinian, international organizations. We looked at statements by the Israeli government, policy documents, planning documents. We sought comment from the Israeli government. So through this, we thought we had a very good factual understanding of how Palestinians are treated by the Israeli government across areas of Israeli government control. The second part of our research was then to analyze the law that governs severe discriminatory oppression. There's a word for that under international law, and that word is apartheid. So while that word, of course, was coined in relation to very specific events in Southern Africa, international treaties, including the International Covenant on the Elimination of Racial Discrimination, define apartheid as a universal legal term. Put another way, there is a prohibition under international law that has the highest status of international law, Jus Cogens norm, customary international law, a prohibition against the practice of apartheid or the practice of severe discriminatory oppression. In addition to that prohibition of apartheid, and this is not something that's in one document that was about South Africa, this is in the fundamental sort of treatises of international law. In addition, the international community, growing out of the horrors of Southern Africa, codified apartheid as a crime, and in fact, as a crime against humanity, set out not only in a 1973 convention on this specifically, that's been ratified by dozens and dozens of states, but in addition, the Rome Statute to the International Criminal Court, the sort of foundational body of international criminal law, lists the crime of apartheid as one of 11 crimes against humanity. Now, taking the definition between these two legal instruments, the Convention and the Rome Statute, apartheid as a crime against humanity, in essence, boils down to three things when they take place together. One, and it's like all other crimes, right? They involve an act, an intent, and a context. So in the case of apartheid, the act involves what are known as inhumane acts. So a series of severe abuses, of very serious abuses and inhumane acts, right? And there's a list enumerated under the convention. The statute lists some examples. So one of it is you need these really severe abuses. The second thing you need those to take place in a context in which there is systematic oppression or a regime of systematic oppression by one group of people over another group of people, right? Now, the criminal doctrines use the term racial group, by one racial group over another racial group, but actually human rights law defines racial group in a way that's much broader, and that's inclusive of distinctions based on national origin, ethnic origin, etc. You also then need, thirdly, so we have the acts, inhumane acts, we have the context, systematic oppression by one group over another, and thirdly, you need an intent to dominate. You need that the dominant group has an intent to dominate over the marginalized group, right? So intent to dominate, inhumane acts, systematic oppression. Let me just flag parenthetically, because this is a lecture about apartheid, that there is a related crime against humanity under international law known as persecution. Persecution in short form, by the way, same status, customary international law, a crime under the Rome Statute, refers to severe abuses of fundamental rights when they take place with a discriminatory intent. I'm going to mention persecution here and there, but the focus will be on apartheid, but I'm very happy because the legal finding is just as significant in the question answer to elaborate on the crime against humanity of persecution. So I said the first thing Human Rights Watch did is look at the facts. I wrote out an entire report just on facts, no legal conclusions. Our legal department wrote out the legal standards, and then we applied the law to the facts, and we reached conclusions that spent many months in the Human Rights Watch review process until our report was published. That conclusion that we reached was that Israeli authorities are committing the crimes against humanity of apartheid and persecution. We based this on those three factors, and I want to walk through them one by one, but in essence, it boils down to an overarching intent or policy by the Israeli government to maintain the domination by Jewish Israelis over Palestinians, which we have found takes place against a context in which there are inhumane acts and systematic oppressions, in particular against Palestinians in the occupied Palestinian territory. So what I want to do in the heart of my remarks is actually to walk through each of these factors and explain how we reached that very heavy conclusion. Again, it's a 200+ page report. I encourage all of you to read the report, but I'm going to provide a very skeleton outline of that, and then I'll conclude with what our recommendations are and sort of where this work is going, and turn it over back to Michael before Q&A. So let me start with the intent or the policy here, right? So as I said, when we looked at, reams of government planning documents, statements by government officials, we concluded that Israeli authorities have systematically sought to maintain domination and control, in particular over Palestinians, in particular with regards to demographics and land. So maximizing the amount of land available to Jewish Israelis while confining Palestinians to dense enclaves, maximizing the amount of Jews that live in the area between the Jordan River and the Mediterranean Sea. We'll talk about Gaza in a second, and minimizing the number of Palestinians. Put much more simply, as some have referred it to, maximum land, minimum Palestinians, right? So let me start with the demographic aspect of this argument. Many Israeli policies at their core are about mitigating what Israeli authorities have openly described as the demographic threat that Palestinians pose. Now, I could give you any number of examples, but let's take one that's been in the news with the now soon to be formally dissolved Israeli government. The 2003 temporary order that essentially forbids the granting of long-term legal status to Palestinians from the West Bank and the Gaza Strip married to Israeli citizens and nationals, a prohibition that does not exist on the foreign spouse of virtually any other Israeli. Now, while formally the Israeli government has said this is necessary for security officials, a long list of Israeli government officials, from Ariel Sharon, who was originally prime minister when this came in place, to Netanyahu, then as finance minister, later as prime minister, to Yair Lapid, to Ayelet Shaked, have all said the very same thing, that this is fundamentally about demographics and maintaining a Jewish state. So I want to be clear that there are many examples that transpose, and I'm happy in the Q&A, and the report goes over examples across Israel and the occupied Palestinian territory. Now, the second part of that is about land. And that policy, again, applies across Israel and the occupied Palestinian territory. So let's take some examples. Inside Israel proper, there is a formal government policy to Judaize the Negev and the Galilee. Now, these are areas where that take up 2/3 of the land in Israel and much of the Palestinian population. And these aren't mere, empty declarations, right? They're followed up by real policies. Take, for example, the admissions committee law, right? That in effect allows small Jewish communities across the country to exclude Palestinians from living there. And where there are, according to research that's been done, hundreds of small Jewish communities that have no Palestinians living there. That moves to Jerusalem, which of course includes, and I know you had a whole lecture on occupied East Jerusalem, but includes occupied East Jerusalem and West Jerusalem, where the municipal planning documents lay out in clear terms that the objective of the municipality of Jerusalem is to maintain a solid Jewish majority. And that municipal plan lays out specific policies to realize that, including confining Palestinians into, dense areas. And it even sets out target demographic ratios that the Jerusalem municipality hopes to maintain between Jewish Israelis and Palestinians. In the West Bank, this policy, of course, is also quite clear. You have decades of government planning documents, such as the 1980 Drobles Plan, that lays out very clearly, that calls for authorities to, quote, settle the land between the Arab minority population centers and their surroundings, end quote. Noting that doing so would, quote, make it hard for Palestinians to create territorial continuity and political unity and remove any trace of doubt about our intent to control Judea and Samaria forever. Again, not just words on paper. Look at the land grabs, the investment of in integrating roads and communications networks and electricity grids that all show the intent for permanence. Even Gaza, right? So Gaza, of course, the government withdrew settlers, it withdrew the ground forces from 2005. But our research of Israeli policy over the last 17, 18 years has shown that Israel has pursued a policy of separation, right? That's the formal policy by the argument by the army between the West Bank and Gaza. And that's been done, and if you look at the way it's been enforced, as a way of taking, in essence, the 2 million Palestinians off the demographic books in Gaza and consolidating a larger Jewish majority across the West Bank, which Israel hopes to retain, and Israel proper, right? So effectively gerrymandering a Jewish majority in these areas. Now, let me be clear. Israel, will often claim security as a justification for many of these policies. But many of the abuses at the core of apartheid, whether we're talking about land expropriation, denial of building permits, whether it be, freezing the population registry, have no security justification, right? Or use security as mere pretext like the 2003 temporary order to advance demographic objectives. But even where security is a consideration, like in the Gaza closure policy, Israel has gone so far beyond what international law authorizes that this cannot negate the intent to dominate or provide carte blanche for crimes against humanity any more than it would justify torture or other grave abuses. All of this, in our mind, and this is again just a skeletal summary, led us to conclude that there is an intent to dominate, one of the elements of apartheid, and a discriminatory intent, one of the elements of persecution. So then we move to the second prong of the analysis. The second prong looks at that context, right? And our research shows that Israel maintains a two-tiered system along the lines that I laid out in the opening of my presentation. And that in the occupied territory, the means used amount to systematic oppression, the second element of apartheid. So what does this mean? Let's look across the occupied Palestinian territory. In the West Bank, and again, I know this is familiar to much of this audience, but it's worth sort of laying this out in concrete terms. In the West Bank, you have a dual system of laws. Palestinians governed under draconian military law, Jewish Israelis under the more permissive Israeli civil law. This is what, in part brought down the government in recent weeks, right? So everybody should be familiar in the audience with this law. That law will be passed, don't worry. The Israeli government also enforces segregation in the West Bank. Palestinians cannot enter settlements except as laborers bearing special permits. The Israeli government not only has pillaged and taken over much of the land of the West Bank, 1/3 of the land, much of the resources, but it separately and equally allocates that, including the 99+%, according to government data obtained by Israeli NGOs, of land that's redistributed to Israeli settler use. It applies to water, roads, etc. Same thing in East Jerusalem. Although occupied Palestinian territory, much of these dynamics persist, including, for example, the discrimination in legal status, where Palestinian Jerusalemites have, for the most part, the status of permanent residents, which means that, if they are to move abroad, if they are to move to another part of the West Bank, they could risk jeopardizing their legal status. It's conditional, unlike the status of Jewish Israelis who are citizens. And there are many, many other examples we could talk about in the question and answers. In Gaza, of course, the Israeli government has imposed, in essence, now 15, we mark this month, 15-year generalized travel ban on the population of Gaza. Nobody in, nobody out, unless you fit within a narrow band of humanitarian exemptions. Again, this is not a security-based policy. Somebody could get a permit tomorrow to go do a surgery that's life-saving in Jerusalem, but the next week, if they want to go on vacation or go for a training, they could be denied. The Israeli government has also restricted trade in and out of Gaza. That has contributed to decimating the economy. 80% of the population are relying on humanitarian aid, unemployment hovering around 50%, the majority of families spending the majority of their day without functional electricity. In addition, and by the way, each of these areas, we have case studies in the report, detailed deep dives of areas that I'm happy to talk about in the Q&A. The report also talks about the institutional discrimination inside Israel proper that reflects the intent to dominate, which includes, of course, the situation in the Negev, where you have 90,000 Palestinians living in unrecognized villages. Michael can tell you all about this because he's been representing communities that have been affected there, that effectively live illegally in their own homes, that face the prospect any day of demolitions, not connected to electricity and other networks. So we found that the means used in the occupied Palestinian territory amounted to systematic oppression. The third and final part of our analysis pertained to the abuses. And we found out that the Israeli government, in furtherance of this intent, has carried out a range of abuses against Palestinians. Our report focused on 5 sets of inhumane acts that we documented in the occupied Palestinian territory. Other groups and other analyses, from the Yes-dין report to the Amnesty report, look at different inhumane acts in different areas. But let me just briefly mention the ones that we focused on in our report, which is not meant to be an exhaustive or exclusive list. The 5 inhumane acts we focused on include: 1, the sweeping movement restrictions, so the closure of Gaza that I just mentioned, but also the restrictions in the West Bank, including the permit regime that requires Palestinians to obtain permits to enter even parts of the OPT, the Seam Zone, East Jerusalem, etc. The nearly 600 closure obstacles and checkpoints scattered throughout the West Bank that can turn a hours-long commute into a humiliating hours-long ordeal, while Jewish Israelis, settlers, have largely unfettered movement. And of course, the separation barrier, which I know was a subject of one of your prior lectures, largely built on Palestinian land, and which puts well over 10,000 Palestinians on the wrong side of the barrier, separates communities from schools, from hospitals, from their larger networks. Second set of inhumane acts that we talked about is land expropriation in the West Bank and East Jerusalem. And with the movement restrictions, it was focused on the West Bank and Gaza. So more than 1/3 of the West Bank, more than 2 million dunams, more than 1/3 of East Jerusalem that has been confiscated from Palestinians, right? And that has reduced Palestinians to living in 165 non-contiguous territorial islands, right? And we talked earlier about the distribution of much of the land confiscated going for the use of settlers and settlements, which again, as you've discussed in the series, settlements are a violation of the Fourth Geneva Convention and a war crime, not putting aside even the discrimination element of this. The third set of inhumane acts we focused on are forcible transfer, in particular in Area C of the West Bank and East Jerusalem. So policies that make it effectively impossible for Palestinians to live legally in their communities, right? We look at government data, for example, between 2016 and 2018, that shows that Palestinians received 100 times more demolition orders than building permits in Area C of the West Bank. That's the majority of the West Bank. In addition to the hundreds of thousands of demolitions of Palestinian communities, of schools, for lacking permits, which is a violation also of international humanitarian law. The fourth set of inhumane acts we focused on are the denial of residency and nationality rights. More than 500,000 Palestinians in the West Bank that are denied the right to live there because they were abroad when the occupation began in 1967, or because they were abroad too long, in the decades that followed, or because of the effective freeze on the population registry. The nearly 15,000 in Jerusalem that lost their legal status because they couldn't prove their center of life, or they maintained connections to Jerusalem, and the list goes on and on and on and on. Hundreds of thousands of Palestinians. And fifth and finally, the report talks about the mass suspension of civil rights for Palestinians. 55 years that Palestinians in the West Bank have been denied the right to free expression, assembly, association, draconian military orders that can put you in prison for years, for a decade, for protesting without a permit, for being a part of an organization that could be considered hostile to the Israeli occupation. And this affects, 4.7 million Palestinians, not, a handful of them. Let me be clear that the report also talks about severe abuses inside Israel proper and with respect to Palestinian refugees. So this, the report looks very much holistically at these areas. So let me talk about what this means. This report was the most stark assessment Human Rights Watch has ever reached on the conduct of Israeli authorities. And our recommendations, the first time we found crimes against humanity. And again, crimes against humanity are different than war crimes in the sense that you are saying that there is a policy or practice to commit this crime, right? It's not merely a case of being disproportionate, or maybe a mistake was made or it was reckless. No, there was an intent or a policy. So our recommendations are consistent with where we found crimes against humanity elsewhere in the world, including finding apartheid in the treatment of the Rohingya in Myanmar, including finding crimes against humanity like persecution in the Chinese treatment of the Uyghurs, including in Egypt, in Iraq, in Syria, and many other places. They include, in essence, in short, and again, I'm happy to say more in Q&A, accountability for the perpetrators. So investigating and prosecuting those individuals that are complicit in these crimes, whether at the International Criminal Court or elsewhere, targeted sanctions against these people that are aimed to stop them from committing these grave abuses. And other forms of accountability and under universal jurisdiction in global courts. But also, we're talking here about ending all forms of complicity in these crimes. And forms of complicity in these crimes include conditioning arms sales and security assistance to Israel on Israel taking steps to end these crimes. It includes vetting all forms of bilateral engagement, all agreements with Israel to vet, to ensure non-complicity in crimes against humanity. Same for businesses, right? Look at all your interactions with in areas under Israeli control by the Israeli government, mitigate human rights impacts if you cannot end those activities. So in keeping with my promise to save a lot of time for Q&A, let me wrap up in the next 5 minutes or so, don't hold me to that, with trying to sort of say what this all boils down to, right? And sort of try to link it, to the bigger picture. A 55-year occupation is not temporary. Denying millions of people their fundamental rights solely because of who they are is not simply a matter of an abusive occupation or an occupation that's gone too far, as Michael put it in his opening remarks. Ruling over millions of people who are denied their fundamental rights for decades on end, including their basic civil rights, is not democracy, or is not democracy plus occupation. A context in which millions of people for decades on end live a reality of structural violence and repression is not simply a matter of a conflict between two equal sides, right? A single system that privileges one people and discriminates against another is not an example of democracy plus occupation, right? A 30-year stalled peace process, and stalled is being kind, isn't enough on its own to dismantle systematic repression. The first step to solving any problem anywhere in the world is to diagnose it correctly. The wrong analysis leads to the wrong conclusion. Imagine you go see the doctor and he's not sure if you have cancer or a common cold. So it's important to think about the question of apartheid because we need to understand what the problem is in order for us to take steps to address it. Apartheid is not simply a hypothetical or a future scenario. Let's remember that Yitzhak Rabin warned about apartheid in 1974. Jimmy Carter, US president, warned about it in 2006. John Kerry warned about it in 2014. We're in 2022. The threshold has been crossed. As Michael reminded us in our opening, our Palestinian friends have been saying this for a long time, but not enough of us listened. Apartheid is the present day reality for millions of Palestinians. Don't just take my word for it. Don't just take Human Rights Watch's word. Don't just take Michael Sfard's word for it. There is a consensus today in the global human rights movement around Israel's apartheid. From international groups like Amnesty International and Human Rights Watch to Israeli organizations. And let me be clear, it's not just Yes-din or B'Tselem or Breaking the Silence. You have groups like Kisha, Physicians for Human Rights Israel, Peace Now, huge, major organizations that have used the term apartheid to refer to Israel's treatment of millions of Palestinians. Similarly, of course, you have other major global voices. You have the UN Special Rapporteur on the occupied Palestinian territory, endorsed by several other special rapporteurs in the UN system, right? You have Harvard Law School's International Human Rights Clinic in conjunction with the Palestinian civil society organization. Okay, let's put human rights organizations maybe at the side. Maybe we think human rights groups, have the wrong analysis. You have legal scholars like Lawrence Tribe, right, that have made similar positions. You have prominent commentators, including, U.S. media folks at MSNBC. You even have pop culture icons, John Oliver and others. In Israel, even if we want to take our lens and just look at Israel, right? You have former attorney generals, deputy attorney generals of Israel, former director generals of Israel's foreign ministry, ambassadors to South Africa, recognizing that one of them overlaps two, categories. You have Haaretz, editorial board. You have members of the current Knesset. A year ago, I spoke at the Israeli Knesset, 54 years from occupation, to apartheid. I could go on and on and on. You have 400 members of the European Parliament and European parliaments writ large. You have more than 50 former European foreign ministers. You have governments. You have South Africa and Namibia, the foreign ministers, the governments who experienced apartheid themselves. But it's not just them. You have the entire African group at the Human Rights Council in March that used the term apartheid. You have the entire Organization of Islamic Conference and the Arab group. So that represents nearly half the world. You have the foreign ministers of Luxembourg, of France, that have referenced apartheid, right? So, I mean, you have the former UN Secretary General, right? If I keep going, I'll talk until 10 p.m. with listing names, right? But why I list all of this is to understand and realize that we're not just talking about some radical fringe thing. We're talking about the collective consensus of those people who work professionally, that have different backgrounds across the spectrum, and virtually anybody who honestly looks at the reality on the ground. We can discuss the geographic scope. We can discuss nuance and differences in different areas, but it's impossible, I believe, to deny the reality of apartheid. And why is it critical that we say it? Why is it critical, in my opinion, that apartheid leads, the conversation? It's critical because so much of our challenge today, really is to move beyond the status quo, to remove the fig leaf, shake up the status quo, remove this fig leaf of the reality that has held us out so much. That when you talk about a peace process or an occupation, you assume, right, that human rights abuse, the core issue is the lack of two sides having a dialogue or resolving a conflict, not structural repression, right? You don't take the sorts of human rights actions that are required of a situation, of this gravity. That's what's needed today. We all want a political solution, all of us, right? But that's not coming anytime soon. And to continue to condemn Palestinians that are being born today, that those of you who live in Gaza, you are being born in open air prison. Those born in the West Bank are being born without civil rights. Those in Israel are born with an inferior status by virtue of who they are. Refugees are born and condemned to, in effect, a lifelong refugee status because they're Palestinian and not Jewish. To continue to tell Palestinians, sorry, you need to keep experiencing crimes against humanity until the world is ready for a political solution is deeply wrong. It's immoral, but it's also not the way we deal with human rights abuse anywhere else in the world. Those of us who care about Israeli-Palestinian peace, whether in a one-state, a two-state solution, or a confederation, should in the meantime recognize and acknowledge reality for what it is. The emperor wears no clothes. Apartheid is the reality on the ground today, and we should bring to bear the sort of tools necessary to end it. Let me stop there and pass it to my good friend Michael, and I look forward to having a good discussion with you for the rest of the hour.
Wow, it's difficult to continue from here. I told you that he's passionate and a very serious human rights lawyer and defender. And while Omar is speaking so passionately, I sometimes forget that we do have some disagreements. And that there are nuances, and I think it's the right place to highlight them and to dig into them a little, because that would be more interesting that way. So I will abuse my power as speaker now, and I'll ask you a question, Omar, even before the Q&A, just to kick-start my comments, which I hope to keep for 15 minutes so that we'll have at least half an hour for Q&A. And by the way, you will be able to ask questions live. If later on when we will open it up, you can raise your hand through the reaction button down in your screen, or you can write a question in the chat, and our good friends at Rosa Luxemburg will read out some of the questions later on. So Omar, before I make my remarks, I want to ask you a question, and sorry for this cross-examination. But does the Human Rights Watch report identify any inhuman act, as is this concept understood under international criminal law, that is committed within the boundaries of the state of Israel, not in the West Bank, not in East Jerusalem, not in the Gaza Strip.
It's a great question, Michael. And I mean, Human Rights Watch in general, when we write reports, right, we are, we're not trying to write legal briefs or legal arguments. We take, the facts, we document them, and we apply the law. So our report was not intended to sort of be the, end all be all of all issues. So we focused, as I mentioned, on inhumane acts, in the occupied Palestinian territories. Now we talk about a range of abuses that affect Palestinians inside Israel along many of the same lines. I mean, I think we'd have a hard time, distinguishing the treatment, and Michael can tell you all about his work with the Bedouins, the Naqab, from the treatment of similar communities just a few kilometers away in the occupied West Bank. We would have a difficult time distinguishing the residency restrictions on Palestinians who, in the West Bank and Gaza from those restrictions also on Palestinians who lived in 1948 Israel and that fled or were expelled from their homes in 1948 and are not allowed to return to those homes. We'd have a difficult time distinguishing the land policies that Israel expropriated from Palestinians in 1948 from those they've used since 1967. But Human Rights Watch in our report, as I noted, focused on what we think are quite clear-cut inhumane acts in the occupied Palestinian territory. There have been different analyses done. Yes-din, of course, focused on the West Bank. We focused across the board, but in the humane acts section on the occupied territory. Amnesty International has done a compelling analysis that includes inhumane acts inside the Green Line. We have other analyses out there as well. So our report focused on the occupied territory, but not to the exclusion or saying that there aren't any inhumane acts in Israel. That was just where we focused on because we think those are relatively clear-cut. But I think there is a strong argument and there's strong evidence to suggest that there are inhumane acts taking place beyond. And I think you can look at a place like Jerusalem, where it's annexed, but you straddle both sides of the Green Line. And even when we're talking about the occupied Palestinian territory, I think it's worth understanding that that the policies that are being committed there, of course, being carried out by the single Israeli government that rules in all areas, and that is implementing policies across the board.
Okay, thank you. Of course, after Omar, it's I think my job in convincing that the crime of apartheid is committed in the occupied Palestinian territories is really easy. I want to reiterate or to remind us all the elements of the crime of apartheid as Omar laid them down. Inhumane acts of severe abuses of human rights that are committed in a context, and it's very important, the context is an institutionalized regime of oppression and domination of one group over another. That's the context. And the third element is that these inhuman acts are committed with a special intention, an intention to maintain, to perpetuate, to eternalize, to make this regime eternal. Now, every regime of occupation, every government of occupation is a government almost by definition of domination and oppression. That's what it is. People are there is no people that I know of that wants to be occupied. No one wants to be occupied. So occupation demands domination and oppression. The Israeli occupation has another element, and that's the element of colonization. The settlement enterprise created a second community within the occupied territory. So we have these two groups, the Palestinians and the Israeli Jews who live in the same territory. And so the systematic oppression and domination is being done by one group over another. And throughout the years, the main alibi for Israel against the charges of committing the crime of apartheid within the occupied territory was that there is no intention to make it eternal. We want to have peace. We want to have a peace process in which at the end, we will part away. They will go their way, we will go our way, and we do not want to occupy them. Well, I don't think I need in this audience to work hard to prove that this alibi has been completely shattered, both by the deeds of the different governments of Israel, which did everything they can to prolong the occupation, to perpetuate it, to create facts on the ground that would not enable any partition and any end to the occupation. But also, since 2017, the deeds were complemented also by words. And we had governments that officially took a policy of gradual annexation of the land. So I don't think we have, I mean, it's by now, when I wrote the יש-דין legal opinion, when I wrote my legal opinion for יש-דין, it seemed to me like it's a very difficult task to prove that the elements of the crime of apartheid are met. But I think today it's almost become almost on the right end of the spectrum of how people look at the reality, definitely around the world, and definitely in the human rights movement. Now, so that I will not delve much into it. You can read the report. The link to both Ommar's report and my report are in the chat. My report, by the way, is only 58 pages, so it's easier to read. And I will not get into the issue of which inhuman acts are being committed. There are ample of inhuman acts that are committed, and some of them Omar has referred to. What I do want to say is I want to make two comments about the geographic scope of the analysis, because as you can see, Omar's geographic, or Human Rights Watch geographic scope, was from the river to the sea. They looked at the whole territory as one unit and asked the question, is the crime of apartheid being committed in that territory? In my report, in the יש-דין report, we looked at the West Bank and we asked ourselves, is the crime of apartheid committed in the West Bank? Now, these are two perfectly legitimate scopes for analysis. And I'll explain why I think it's legitimate. The apartheid crime, the crime of apartheid, is a crime that deals with a system of governance, with a regime, with institutions. It's not me discriminating against someone on as a private initiative. We're dealing with an institutionalized regime of discrimination. So we need to ask ourselves, what is a regime? Now, there is no question that between the Jordan River and the sea, there is one political power that is dominating the territory, and that is the government of the State of Israel. That is, of course, true, and we all know it. But can we look at the territory and say that this one political power dominates or manages several distinct regimes? That's the question we need to ask ourselves. And if a regime is taken and understood as the combination of a normative framework or legal framework, laws, bylaws, etc., policies and practices, public institutions like a judiciary and an executive and a legislator, and that are all controlling a territorial unit, then definitely in the past it was easy to say that there is a military regime in the West Bank with its own laws and orders and its own institutions and policies and practices, and there is a parliamentary regime within the 1949 borders of the State of Israel, within the Green Line. Now, this description is a bit misleading because there is a lot of interaction between the two. And we have today many Israeli institutions that have powers within the West Bank. The Antiquities Authority, the National Parks and whatever authority, the Ministry of Education runs schools in settlements, the Ministry of Health runs clinics. So we see that it's not a clear cut. what we're witnessing is a process of unification, both bureaucratic, but also normative unification of these two. When will we not be able anymore to say that it's two regimes? I don't know. In the report, I made the following metaphor. It's like two stars that are rotating around each other, and one of them is constantly shedding matter on the other. There is a point in time where every spectator would say, this is one star. This is no longer two stars. So we're in this process. I can't say when we will not be able to say anymore that there is a different regime or a distinct regime in the West Bank. Why is that important? Because criminal acts have a place and time of commission. It's not enough to say, you can say Israel is an apartheid state. Okay, that's not a legal statement. It doesn't have a legal understanding. Israel is committing the crime of apartheid, or Israelis are committing the crime of apartheid. Crimes are committed not by states, but by people, and they are responsible for those crimes. Israelis are committing the crime of apartheid is a valid statement, but then one might ask, when was this crime committed and where was this crime committed? Okay, every indictment from the simple charge sheet for theft and for a war crime or a crime against humanity has to stipulate when and where the crime was committed. Now, for me, it's clear that in human acts, which is the act, that when is committed in the context of this institutionalized regime of domination and oppression of one group over the other, and with the intention to maintain that regime, that's when the crime is committed. So inhuman acts are committed every day in the West Bank, every day in the West Bank, in East Jerusalem, I would say, even in the Gaza Strip. I'm not sure that I can say the same about Israel proper. Here comes the question of when a discrimination, and there are many countries in the world that discriminate against minorities. When a discrimination, and even institutional discrimination, even in a discrimination that is ingrained in the character of the regime, when does that become apartheid? And that's a big question. We don't have case law on apartheid. No one, because the South African story ended as it ended, with truth and reconciliation commissions, etc., there is not a single person that was ever indicted for the crime of apartheid. So that question rests with us. We need to remember that this feature of domination and oppression of one group over another has to be a central key component of the character of the regime. It's not another thing. And each one of us should ask ourselves, is the discrimination of Palestinians in Israel, Israeli citizens who have the right to vote and to be elected, and we all acknowledge that they are discriminated against severely, that their political power is being diluted in all kinds of ways. Is it enough to reach the degree in which we'll say this is the central feature of the Israeli regime or government? So this is one question. And the second question is, when we have a government in which the discriminated, the oppressed group does have the main civil rights to vote, to be elected, to be represented, to run for government, what is the standard that is needed in us to say, well, although they have all these rights, this is still an apartheid regime? And each one of us can think of, for example, the question of Blacks in America, right? Who are severely discriminated against. The discrimination against them is institutional. It goes way back. It's chronic. There are many systems to empty their political power. There are many ways that this is being achieved, including gerrymandering. Gerrymandering is a concept that was coined in that context. Can we say that there's an apartheid regime in America? I'm asking questions. I don't have all the answers. As I said, the crime of apartheid is a crime that was never litigated. So for me and for Yesh-Din, it was easy to say, we definitely know for sure that the crime of apartheid is committed every day in the West Bank, and I add in East Jerusalem and in Gaza, because we know what's going on there, because the crimes are committed today. The confiscation of lands is done today. It has not. There are many inhuman acts that have been committed by the young state of Israel when it was just established. There's, I think, could be very little disagreement about this. The immense expropriation of lands that was done, lands of the Israeli-Palestinian citizens. And of course, the Nakba and the forced transfer and the deportation of Palestinians who became refugees. That's, I think, cannot be disputed. The question is, can we take these inhuman acts that happened in 48 and say these are inhuman acts that are still ongoing because they have not been remedied? This is a legal question, a very serious one. These are the kind of questions that the international human rights community is now asking itself and dealing with on a daily, and when I say on a daily basis, this is on a daily basis. Omar and I and others from different organizations are constantly debating and talking about these issues, because these issues are extremely important. But there is no disagreement that Israelis are committing the crime of apartheid against Palestinians, whether it is in the West Bank or for some within the state of Israel itself. So I'll stop here. Omar, do you want to say something?
No.
We open it?
Yeah, well, while we maybe get ready to questions, let me just sort of quickly add a few things to that. I agree with Michael's that there are multiple legitimate approaches you can take in terms of how it's your lens by which you look at the question, right? And so what I wanted to though do is maybe challenge a few of the points Michael made, just in terms of the frame of analysis and sort of open it up. So to me, I think when I think about the crime of apartheid being a crime about domination, I think about who is the power that's dominating, and who are the groups being dominated and benefiting. And there's no doubt. I mean, you can't really dispute that the overarching dominator is the Israeli government for the benefit of Jewish Israelis wherever they live, to the detriment of Palestinians wherever they live. So to me, a crime about domination by one power of two people, that lends itself to that analysis. And I think what's important for me, when I think about this question, what's important to remember is that apartheid is not a regional anachronism. It's not something that's just about some region, right? And I'll get to the crime point Michael made. And I think what's important to remember is the treatment, the discrimination, which nobody denies, of Palestinians inside Israel is a part of the larger system of domination, subjugation of Palestinians. Nobody will deny that, right? And I mean, and when you start thinking about this question of regime or system, I think there's some questions that you have to think about, right? Which is, what regime do Israeli settlers fall into, right? Are they in the West Bank regime? I mean, technically, Michael has written about this in his book, they're, pipelined into Israel proper, but, that's sort of a legal form, that's formalistic. We all know that Jews live in one regime, one system, wherever they are, right? They move freely, they go back and forth. Doesn't matter where you're born, you live with the same rights everywhere. So how is it two regimes? If for one of the two groups, it's one regime everywhere, right? And then for the other group, it's discrimination at different levels, but always discrimination. And not just that, but the difference between Gaza and the West Bank, right? may be more different than West Bank and Israel proper, right? I mean, you could even say the repression in the Naqab might be worse than in Ramallah, right? So, but also more than that, you have to understand that the architecture of domination, right? To understand it, you have to understand 1948, right? You have to understand that Palestinians were in military camps for 2 decades, that Israel only lifted that regime when they had solidified control of the land, that the whole apartheid system requires that refugees not return. So yes, maybe the scale of abuse today isn't what it is before, but the architecture, the system has been rigged, right? It's been set up so you don't need that level of abuse inside Israel because you've already created a system that got you that output by that event, the events in 1948 and 1967. And so when I go back to 2 regimes, these are I think the questions that, come to my mind. And then finally, I'll add, Michael's right about location of a crime. He's a lawyer. He knows this stuff. But, right, one important, caveat I would make is when you say a bank was robbed in New Jersey, right? Let's say you say the bank's robbed in New Jersey, that doesn't mean it was robbed in every city in New Jersey, right? Even if you say the bank was robbed in Newark, it's in a very specific bank location there. So if Michael wants to take that point all the way to its end, is there apartheid, say, in, the center of Ramallah, if you want to, or in Area A, or in, Gaza by itself, right? It's all how you define the analysis. Human Rights Watch is not saying that it's apartheid in every square inch of the territory, that's there as a crime, right? We're saying that we're talking about one system, and that one system, there is apartheid being committed, and that it involves this intent or policy everywhere and very specific inhumane acts. And we enumerate a non-exhaustive list. So I think the point I wanted to make before we open it up is just to sort of make sure we contextualize these questions of location of crime and regime and system, right, in the context of that reality on the ground. I think most of this audience lives in Israel-Palestine, and I think most of us know that when you're on the ground, there is a legal distinction between Israel and the West Bank, but on the ground, that distinction rarely matters, to most people.
I can assure you that Omar and I can continue like that for days. But we won't. So if anyone wants to ask question, again, you can either write in the chat or raise a hand. I see that there is a, so
Hello.
regarding
the fact that there really isn't any legal history about how international law should act or react to the crime of apartheid, are there, even though that fact, are there any suggested procedures or doctrines or rationales, however general, about what should be done in these cases once it's proven that there is an apartheid happening, and once the international power balance shifts toward action?
Okay, I think we'll take a few.
There are 2 or 3 questions in the chat that I can add. One is, can you elaborate about the stats of the pending ICC investigation? Any updates? Also, did you recognize a systematic trial to separate the West Bank from Gaza since 67 or even 48? And another question about Gaza. Gaza is not under Israel rule. Why is it considered the same as the West Bank? Okay, these are the questions in the chat for now.
Okay, Omar, you start. Go ahead.
Sure, and we can tag team on this. So, great question. The first question I was asked by the colleague is a great one, and Michael's right when he says that we don't have case law and precedent on the crime of apartheid. So, although it's well established, the prohibition and the crime, we don't have much in the way of precedent to understand what terms like domination or inhumane acts means. So when Michael and I are having this debate, we're doing it without the benefit of like courts having developed the jurisprudence. And by the way, if I had to ask a question back to Michael, I would ask him the question of, do you think that what's happening in the Naqab isn't not an inhumane act? I would be curious as a lawyer for the affected communities if he would say it's not an inhumane act, but we can leave that aside. But in terms of precedent for what should be done at the International Criminal Court, the Rome Statute, for example, identifies apartheid as one of 11 crimes against humanity. So it defines the term, but it merely defines the jurisdiction or the basis by which the International Criminal Court prosecutor's office could eventually indict and bring, charges against particular individuals for this crime against humanity, right? So maybe I'll answer the ICC question here in the context of that, which is to say that the ICC has opened a formal investigation that was done at the end of the last prosecutor's reign. So there is an open formal probe into crimes committed in Palestine. So let me parenthetically note that the jurisdiction of the court, because the court does not have jurisdiction everywhere in the world, it's limited by the terms of its statute. One of the bases for jurisdiction is when member states agree to the jurisdiction of the court in Palestine. And this was a case that actually went challenged at the ICC of whether Palestine can claim jurisdiction over its territory based on whether or not it's a state. The court found that it can. There is jurisdiction over Palestine, that could be challenged later. So the court has jurisdiction in the occupied Palestinian territory. There is a formal probe, and we're now waiting for that probe to see where it goes. The prosecutor will have to do several things, including to establish whether there is sufficient jurisdiction on another basis, which is what's called complementarity. So the ICC will have to determine that Israeli and Palestinian authorities are not willing or unwilling and unable to investigate abuses of the ICC jurisdiction that take place in that territory. And secondly, they'll have to determine that crimes under the jurisdiction are being met. That's what they're investigating. And then if they believe that's met, they will indict individuals for these crimes. So investigation can take a long time, months, years, but there is a formal probe and the ICC is looking into that. In terms of what it means beyond criminal accountability, the Apartheid Convention lists out very specific things states need to do. You can read the convention. Most of it's about this, things like non-complicity in the crimes, avoiding entangling yourself in those abuses, actions that should be taken in order to ensure that you're not complicit or contributing to those abuses. In terms of the questions on the West Bank and Gaza, I would say about the separation, Michael also raised the question of when is apartheid committed? Human Rights Watch doesn't answered the question of when apartheid started, decades ago, 5 years ago, 10 years ago, because we're not a historian. We're a human rights group that documents the reality on the ground today. And we found today apartheid is being committed. And that part of that policy includes a separation policy. We focused again on, since 2005, because that's really, there was a substantive shift in 2005. But you can, historians and can probably find traces of that even before. But I'm not going to answer that here because that was not something we got into in our research because we don't look back. And the last question, I believe, was about, the West Bank, Gaza being the same as the West Bank. And I think that actually brings up my larger point that apartheid is not a crime about formal sovereignty, right? Apartheid cares a little bit less about who formally the power is. It looks at domination, who is in fact in control, in practice. And so while Israel, is not formally the sovereign inside Gaza, the UN, the ICRC, the Red Cross, Human Rights Watch, most governments in the world still consider Israel to be the occupying power in the Gaza Strip. And in fact, and the report goes in depth about the metrics of control that the Israeli government maintains over Gaza. So by that virtue, right, by the virtue of its control and its domination, we are assessing that the crime of apartheid is being committed, including vis-a-vis the Palestinians that live there.
I will just add about Gaza for the sake of the person who asked about its status. I don't agree that Gaza is not under occupation. Gaza is under a form of Israeli occupation. We might have taken our citizens out of Gaza and we don't have permanent land presence in Gaza, but we do control the airspace of Gaza. We control all the borders, including to some degree the border with Egypt. Through the Egyptians, definitely the maritime border. We decide who comes in and who can go out and what goods can come in and can come out. No one in Gaza is allowed to be born or to die without us making a note of it. So a person is not becoming a legal personality without Israel's registration. Israel controls the population registry. So we have a very large degree of effective control over Gaza, and to the degree that we have control, we also have responsibility. And so Gaza is under a form of occupation. I will take the challenge and say, Omar, of course, the Bedouins of the Negev are suffering from inhumane acts that are committed against them. It is, of course, the crime of persecution is committed against them. There's no question. They are being probably the most abused group. There's a big competition, but one of the most abused groups in the region. The question I asked about if the Israeli government within the Israeli borders can be defined as a government that commits crimes of apartheid deals more with the question of the degree of domination and oppression. As I said, if that corresponds, then what about other governments that dominate and oppress minorities? Let's move on to the next questions if anyone has, or in the chat if we have more. Tamar.
Yes. Are there like hands raised, or should I continue with the chat?
Please continue. It seems people are shy.
So, there is a comment and the question. The comment is, I think the term apartheid is misleading because apartheid is separation and segregation. Zionism, however, means Palestine without the Palestinians. It will never end until the last Palestinian leaves his homeland. And this is a try called genocide. To stop is a regime change in Israel urgently needed. And the question is, are there steps that the PA could take in order to move forward towards accountability in an international forum of Israel systemic or systems crimes of apartheid?
Yeah, maybe I'll just give very quick answers and then pass it to Michael. I would say in terms of, those definitions, look, apartheid can be defined in different ways depending on what your lens is. You can talk about apartheid as in a historic context, a comparative. You can look at the Afrikaan word. You can look at different things, but we're very clear in the Yes-dין report, the Human Rights Watch report, we're talking about the legal term apartheid. And the legal term apartheid does not mean separation or segregation. It means, and you can read the exact definition, inhumane acts, committed in the context of a regime or in the context of systematic oppression by one racial group over another, and with the intent to maintain the domination by that group over the other. That's what it means, and that's what we're talking about here. Similarly, when you talk about genocide, you're talking about a very specific crime that is very specific definition. And so, these are legal terms, and that's how we use them. And when we say a crime is being committed, of course, we're calling for specific things to be done to end the commission of that crime, which includes recommendations around how to ultimately change that. Like Michael, we don't use the term apartheid. We don't use the term apartheid state. We don't even use the term apartheid regime any more than we use torture state or torture regime, or it can be used colloquially, but legally we talk about the crime, the prohibition of apartheid or the crime of apartheid. In terms of steps the PA could take, I think it's worth again noting that we're talking about individual criminal liability. I mean, you can talk about a state responsibility or the prohibition, but we're talking about a crime. We're talking about individuals committing the crime. So that can happen at the ICC, but right now there's a formal probe. Palestine is already acceded to the Rome Statute, so there's jurisdiction on that basis. So from right now, any steps forward at the ICC will be the decision of the prosecutor. Obviously, there could be political pressure and influence, but I think we all hope that the prosecutor will base that decision purely on a legal consideration. There are steps other states could take under the doctrine of universal jurisdiction. For example, we've seen prosecutions and convictions in Germany of Syrians involved in crimes against humanity and war crimes. There have been initiatives over the years in other countries, but that's not dependent on the PA. That's dependent on the actions of courts acting under their own jurisdiction.
I will add, and I will address the issue of genocide. This is not something that I have looked into and studied, but from the little that I do know about the crime of genocide, the crime of genocide includes a very unique type of intention. and the intention in the genocide, in the crime of genocide, is to extinguish a certain group or part of that group, to eliminate it, to wipe it off the land. And it seems to me a huge stretch to say that there is such intention within the Israeli apparatus. I'm saying it mildly. I don't think there is such intention, and I think the genocide is not a concept that has bearing in this conflict. I would add to what Omar said about segregation and separation not being a component of the crime of apartheid, that the crime of apartheid, as it been defined in international criminal law, is not even a crime that is based on that has a requirement of some racist motivation. Okay, in general, crimes do not include, in general, even regular crimes. They do not require specific kind of motivation. They require a certain kind of action and sometimes intention, which is different than motivation. Okay, I have an intention to reach some kind of a goal. A motivation is a different thing. And if someone kills another person because he hated him or her, or because he wanted their money, or because that doesn't bear at all on the question of guilt. The motivation is external. And this is sometimes an issue that is difficult to grasp, because we all know how the word apartheid came to being. Came to being in a very racist government of South Africa with a theory that had a theory of race. Now, I want to say that on the one hand, again, this is not something that was imported into the legal definitions. And on the other hand, there is enough racism in our system. So let's not try to look there for the rope that will save us. In that context, I would like Omar to raise one more thing, because I know that many people have been asked about it constantly. Would you elaborate a little about why the concept of racial groups should not be confined to races, especially when given the history of the concept of apartheid, which was domination of one race over another race, and not other types of group dominations.
This is what makes this conversation fun about Michael, because I'm pretty sure I asked him this question when we were researching the report. So, you know, it's we've come full circle on it. But I mean, look, when we define any term, you look at precedent and you look at how similar bodies, and I'm sorry to be competing with the prayer call here in Jordan. So you look at how, other bodies have interpreted it. So here, the major relevant bodies would be human rights law and would be criminal law. So under criminal law, tribunals have not dealt with apartheid, they've dealt with persecution, right? So they've dealt with other crimes that are about racial, ethnic. And what they've done is they said you need to use a subjective definition. What I mean by that is what it looks like in the context, right? Look at the eyes of the perpetrator and try to understand sort of what the cleavages are there. And if they make distinctions based on, and they've said that racial should be seen in a more broad way, because, and this goes with where social sciences are. Race isn't, black and white, like in stone, right? It's a social construct that takes different meanings in different areas, and you need to look at it with that in mind. Similarly, human rights law, you can look at the International Covenant on the Elimination of Racial Discrimination, or look at decades of the committee that's charged with interpreting that statute, interpreting that in a way that includes those other sorts of distinctions. So that's the basis. And of course, you can look at what Israeli law does. And Israeli law recognizes, even though
that's when we talked about it.
Exactly. And under Israeli law, there are of course Arab Jews, right? But under Israel's system, they're Jews, and there are, Arab Palestinians who are, are Arabs under the Israeli legal system. And you can look at cases around, and this again, what we talked about with Michael before, around incitement to racial discrimination under Israeli law that has been used to, exclude candidates from the Knesset elections, and then include speech against Palestinians. There are many, many other examples, but I wanted to sort of highlight that. And maybe just while I have the mic, I see a quick question I can answer in 10 seconds in the chat, which is, why does Israel use apartheid versus, other terms? Simple. Our mandate is international humanitarian and human rights law. Apartheid is a legal term. Occupation is a legal term, but ethnic cleansing or criminal occupation or apartheid state are just not legal terms. So others can use those terms, but we agree with Michael fully. Occupation applies. The law of occupation applies. Even when I talk about one regime or one system from the river to the sea, we still talk about two different legal entities, being the occupied Palestinian territory and Israel proper.
Okay. I think we have time for one more, or we'll wrap up.
Maybe just one comment from like it says, as I grew up in apartheid South Africa, on the right side, thanks to my skin color, I've for decades seen apartheid developing here and have been outspoken about it. The big difference is that South Africa never denied what they were doing, whereas in Israel, denial is so strong that it will never reach a grassroots level. So maybe you'd like to comment on this.
Yeah, I mean, the first thing is to say, obviously, there are many differences and distinctions. It's not a carbon copy. And, if you look at what torture looks like in the US versus in Egypt, it's going to look different, right? When you talk about two crimes. But I will say, and I will challenge the premise of the question by saying the Israeli government has been a lot more explicit in the last 5-6 years. And Michael talked about this, about its intentions. Netanyahu talked about, ruling over the West Bank in perpetuity, Palestinians as subject. The nation state law of 2018 enshrines as a constitutional value, for God's sake, that certain key rights only belong to one of the two groups living in this territory. You have people that directly tell you that the purpose here is to maximize the land for Jews and demographics and So they might not use the word apartheid because now apartheid is recognized universally as bad and as a crime. But if you look at the constituent elements of it, while the Israeli government for years said the occupation is temporary, and Michael would try to argue with them in courts for decades about exposing that lie, they even stopped caring about the pretense of legality in a lot of cases. So I would challenge the Israeli government. They don't accept the term, but of course the legal term grew out of what it meant in that cultural context. But the Israeli government isn't hiding about its intentions, and its intentions are to maintain the domination by Jewish Israelis over Palestinians, including through maintaining a system of repression and serious abuses against them. Full stop. You can find replete evidence that lays that out, as I mentioned in my remarks.
So this is a good note to end, not before we'll say that we will dismantle the apartheid, and that I hope that we will meet next year in Tel Aviv or Jerusalem, Omar, because the fight not only to dismantle the apartheid, but also to allow you into this land where your work is extremely important, is not over. Thank you all for joining us. Next week, same day, same time, we will have a meeting with a guest speaker, attorney Abir Baker, a good friend and a very, very, very good lawyer. And we will be discussing prisoner rights in the context of the occupation. So thank you all for joining.